In general, a premises liability case refers to any type of a case where a person is injured on the property of another. That can be a person's private residence, it can be a company's property, it can be a construction site, or even public property. Just because you're hurt on someone's property doesn't mean that you can automatically recover under the personal injury laws. In order to have a personal injury case, the law generally requires that you be able to establish that the owner of the property or someone who exerted control over the property was negligent in their conduct such that it gave rise to the condition that you were injured on. If you suffer an injury on someone's property, one of the areas of important inquiry are, does that property owner have what's called medical payments coverage? In the context of medical payments coverage, sometimes property owners have that coverage. It's generally a lower amount of coverage, but if they have that coverage, you may be able to submit your medical expenses for payment under that coverage, regardless of being able to prove if someone was at fault for the injuries. This can help sometimes defray some of the costs related to an injury. If a person is hurt as a result of a condition that we refer to as an open and obvious condition or defect on a property, meaning that it's so apparent that someone should see it and avoid it, the law provides defenses for property owners or people in control of a property where one of those conditions exists to protect them from liability. However, there are exceptions to those defenses, and they really require a fact-specific analysis to look at factors as to why a person may be injured. One of those exceptions would be if there's a condition on the property or the nature of the area that would cause a person to be distracted. But if you believe that you've been injured, you should still consult with an attorney, even if you think it was an open and obvious condition, so that your rights could be determined as to whether you have an appropriate claim. If a property owner or someone in control of that property is not aware of a condition that causes someone to be injured, the law does provide some defenses for that. However, there are exceptions if a person doesn't have notice, and some of those exceptions include that the condition was on the property for so long that the owner should have had notice of it. Other exceptions include that the conduct or the business of the property owner ultimately caused or created the condition that gave rise to the injury. But in general, it's a fact-specific analysis, and if you believe you've been hurt in this scenario, it's wise to consult with an attorney. In certain types of cases where someone to engage in an activity signs a document called a release, under the law they might also be referred to as an exculpatory clause. You may have seen this in everyday life. If you go to somewhere, a health club, to participate in health club activities, oftentimes you'll be asked to sign a document that in essence will release the property owner or the person in control of the property from certain aspects of negligent behavior. These documents need to be read very closely before being signed, but when they are signed by an adult, they may have the effect of limiting a person's ability to pursue a cause of action. There are exceptions when they're signed. Behavior that rises to willful and wanton or reckless behavior may be able to get over the limitations of a release or an exculpatory clause. It depends on how the document is drafted. So just because you've signed a release or an exculpatory agreement doesn't mean that the property owner can't be held liable, but it requires a legal analysis. Living in the Midwest, difficult weather conditions are something we've all unfortunately had to get used to, and that includes snow and ice. There can be viable cases for slipping on snow and ice. Oftentimes it requires an analysis or a determination on where the ice came from, what caused it to be there, and in some circumstances there are even statutes that protect residential homeowners against falls from snow and ice. Generally, when we have snow or ice that's created by the natural conditions, a natural falling of snow onto the ground or natural creation of ice from the weather conditions, we refer to that in the law as a natural accumulation of ice or snow. In general, the law makes it very difficult to pursue cases arising from a natural accumulation of ice or snow. However, there is a condition that we refer to as an unnatural accumulation of ice or snow that is often actionable. An example of that would be where a building is constructed in a way that it sheds all of the snow or precipitation from the roof into a gutter, and in my example, the gutter would discharge right on the main walkway near an entrance. In that context, we would consider that an unnatural accumulation, where it's not the natural falling of the snow or ice that creates the dangerous condition. It's the system of gutters or roof that directs it to an unsafe location that causes an injury. And this can happen in many different contexts. That's one example, but unnatural accumulations of ice or snow can be actionable. There are limitations on when a property owner is responsible for an injury that happens on a premises. And so for an example of if a person is at, say, a grocery store and is walking down an aisle and they take something that they have in their hand and throw it on the ground and someone slips and falls on it immediately thereafter, that's a situation where the property owner really would not be in a position where they would know that that would be there, and it would be extremely difficult to find the property owner responsible. However, in that context, there may be liability against the person who's doing something like throwing something on the floor when they know they're in a public place. And what it really highlights in the area of premises liability is that the facts are always so unique and so different, and that's why you really need to evaluate them closely and then apply the law. Oftentimes people, when they think of premises liability cases, they really focus on issues like slipping on ice or slipping inside a store, but premises liability cases really can involve a lot of other types of injuries. It can involve, defects related to a property and its construction, where a part of the structure can give way. In an example like a porch collapse and people can be hurt. It can be in the context of a construction site where the conditions on the site and how the site is regulated can relate to the premises causing an injury. So if you've been hurt and you've been hurt on someone's premises, there are a lot of different ways that those cases can evolve. And if you have any question as to whether you have a case, surely consult with an attorney and they can advise you and give you more information.